We have an interesting story today. Tactical wanted to cover it, and I then saw that you guys had submitted it already. SidAlpha made a video on this as well, and I thought I'd go over the legal part in detail, as I do, of this independent author. Well, I don't know how independent, but, you know, not Amazon, not the Tolkien estate, author, wrote fan fiction of Lord of the Rings, it seems, and sent a copy of it to the Tolkien estate, and then never heard back from them until later on, seeing the new Fellowship of the Rings, is it? Rings of Power, excuse me, that Amazon's doing now. And now all of a sudden he thinks that Tolkien and Amazon have taken license with the content that he's created. So we're going to take a look at this today and see what has been copied. Is there any basis to this lawsuit? What's involved? You know, is the author loony, or they actually have a basis for their case? And we'll go through it together and see what's happening. If you haven't seen SidAlpha's video on it, he does a good 11-minute summary of what's going on. Mine will probably be a little bit longer, so feel free to hit the speed up button if you're watching this on YouTube. Tactical pulled the complaint for us, so let's first take a look at what he has filed, and then we'll decide from there what's going on and how we feel about it. So our plaintiff here is Demetrius Polychron, an individual, versus Jeff Bezos and a bunch of people, including the Tolkien estate, and defendants 1 to 100. And they're suing for copyright infringement, contributory copyright infringement, vicarious infringement, and unfair competition. Some of that's going to be duplicative, redundant. Polychron, plaintiff, prior to September 22nd, 2022, wrote and published an original book entitled The Fellowship of the King, and conceived an entire 7-book series, The War of the Rings. Plaintiff's above-referenced book contains a substantial amount of material created by plaintiff's own skill, labor, and judgment, and is copyrightable subject matter under the laws of the United States. On or about November 21st, 2017, so going back 5-6 years, Polychron complied in all respects with the copyright laws of the United States and all other laws governing copyrights, and secured the exclusive rights and privileges in and to the Book of Authorship, receiving from the Register of Copyrights a certificate of registration dated and identifies as follows. So he's got a, as she said, 2017 copyright registration for Demetrius Polychron in the Fellowship of the King. Plaintiff is the proprietor of all rights. Okay. Since September 22nd, back to 2022, the above-mentioned book has been published by plaintiff, and all copies of it made by Polychron or under his authority or license have been printed, bound, and published in strict conformity with United States copyright law. Tolkien, the grandson of J.R.R. Tolkien, the author of the Lord of the Rings book series, is a controlling shareholder of the Tolkien estate, and Tolkien Trust, and Tolkien Estate Limited, etc. Here we go. November 21st, 2017, Polychron sent a letter to Tolkien explaining his love of the Lord of the Rings books, describing his authorship of the Fellowship of the King, which was largely inspired by Lord of the Rings. Keywords here, inspired by. In this letter, Polychron sought review of the Fellowship of the King manuscript by Tolkien. Polychron received no response. So he's got this dream of writing something for the Tolkien estate, and they don't respond to him. Subsequently, November 17th, 2019, with excitement to collaborate with the defendants in anticipation of publishing his book to the public, he retained counsel to contact Tolkien. His letter detailed descriptions of his book and series with the request for review. The defendants, by counsel, rebuffed any attempt at collaboration on the very next day. So he goes through all this work writing this fan fiction, and he hopes to get it published through the Tolkien estate, get them to be interested in publishing his work or working with him on it, and they finally reject him. And then the second time, he hires a lawyer to write a letter because he figures that will get their attention. It does get their attention, and they say affirmatively, no. I think he was disappointed. December 24th, Christmas Eve, 2019, Polychron delivered in person to Tolkien a copy of the manuscript identified with a copyright symbol at his home in Santa Barbara, hoping he would review the manuscript and reconsider collaboration. January 14th, I'm guessing the 24th was the 2018 and this is 2019 now? I don't know. On or about January 14th, 2019, after Polychron received no response, he sent a letter asking him to return the manuscript and advising him that he would publish it and an additional 6 books independently. Following Tolkien's review of Polychron's copyrighted protected manuscript, the Defendants collaborated to create a television series. Okay, so now they're establishing a substantial similarity and then access, because that's a component of copyright infringement under the substantial similarity test. So, they had access to his manuscript, and then, fast forward, they make a television series independently. The Lord of the Rings, The Rings of Power. While the agreement reached between Amazon Studios and the Tolkien estate to create the series occurred on or about November 13th, 2017, The Rings of Power was ultimately copied largely from Polychron's copyrighted book, The Fellowship of the King. As a result of the agreement, the Tolkien estate paid Amazon Studios $250 million for the rights to the series. Wait, the Tolkien estate paid Amazon? Tolkien estate paid Amazon? That ultimately copied Polychron's book and the work, and upon information and belief has earned Defendants even more since the release of the series. In writing The Fellowship of the King, Polychron, while admittedly inspired by The Lord of the Rings, okay, I think that's going to be important, developed a wholly original work and concept for the work, including separate and distinct characters and storylines separate from the Lord of the Rings series. These wholly original and distinct separate characters and storylines compose as much as 1/2 of the 8-episode series as released and published by Defendants. In many cases, Defendants copied exact language from The Fellowship of the King. In other instances, Defendants copied images that matched the book cover and descriptions. October 19th, 2022, despite the Defendants' knowledge of Polychron's copyrighted book and in blatant disregard for their infringing use of his creation, Defendants caused to be registered their copyright registration. They're expected to release 4 seasons of the show, and we've got the claims now. So claim 1 is infringement of a federally registered copyright. Department of Redundancy Department. Those state-registered copyrights, those pesky ones. At all relevant times, plaintiffs have been the creator of the book, and without authorization, Defendants took characters, stories, images, and exact lines from plaintiff's book and copied and published them in the 8-episode season of the series. $250 million in damages. Defendants knew their acts constituted infringement. Defendants knew their acts constituted copyright infringement. As a result of their wrongful conduct, defendants are liable for copyright infringement. Okay. $250 million for direct infringement. Contributory copyright infringement is directed at somebody. Somebody induced, caused, and materially contributed to the infringing acts. This is a shotgun complaint. We're just going to name all the different copyright claims, and then just put them in here. Again, vicarious copyright infringement, same thing. No defendants named for that one. Unfair competition. Defendants have, I guess, competed against him. Copyright is federal. It's preemptory, meaning so copyright preempts other laws. So if there's unfair competition and copyright, then you sue for copyright. Is usually how it's done. I guess you could bring like a state law unfair competition claim and not bring a copyright claim, but if you bring both, one's going to preempt the other. Okay, so that's really loose. That, in my professional opinion, that is a sort of bare bones complaint. Very, very favorably written. But there's one thing at the end here that we sort of forgot. So they go through like we want all the normal things: profits, $250 million, physical, digital copies, impounding, statutory damages, costs of the action, etc. And then there's this you don't normally see: a verification. I am the plaintiff in this action. I have read the foregoing complaint, and it is true of my knowledge. I declare under penalty of perjury under the laws of the state of California that the foregoing is true and correct. Demetrius Polychron, April 14th, 2023. Why would you include a verification paragraph in a federal complaint? You don't normally need to have a verification paragraph in a federal copyright complaint, if I recall correctly. Now, maybe something's changed. Maybe there's a rule in this particular court, the Central District of California. No, I'm not aware of one, but you know, maybe I'm missing something. I'll look it up. But you normally don't have to verify a complaint. So a complaint where the plaintiff swears to the allegations demonstrates to the court that the plaintiff has investigated the charges against the defendant and found them to be of substance. In many jurisdictions, a complaint does not need to be verified unless specifically stated otherwise. So it's an extra step to tell the court this defendant has reviewed this federal copyright complaint against the Tolkien estate, and he swears it's true and correct. And my initial reaction to that one was, if I was an attorney filing this lawsuit, I would also want to cover my butt by making sure everyone, including the court, knew right off the bat that this is this guy's allegation, not mine. Although the attorney still has a Rule 11 and professional conduct responsibilities for due diligence, that seemed to me to be a little bit of a CYA moment. Attached to the complaint are some interesting things. They attach the copyright registration, as we saw before, but then they also attach this list of similarities. This lists the TV series on the left and the book on the right. So plaintiff on the right and defendant on the left. And some of these are really telling. So he's saying that the exact image of the cover of my book appears at 5 minutes and 11 seconds when a dragon destroys a great eagle in flames. I'm assuming it's not like they just don't like put his book cover up on the screen, right? Like there's an actual, like a dragon destroys a great eagle, right? Like on video, like somebody's made CG of this. Someone has made computer generated graphics or imagery of this. So how could it be the exact cover of the image of his book? Meanwhile, Galadriel becomes a warrior and takes up Finrod's sword. Meanwhile, he wrote, led her people into the thick of attacking orcs. Meanwhile, there's a hobbit named Marigold X, and meanwhile, he wrote something about Aunt Marigold being scared half to death. Okay. Then there's a person of color named Malvia, and he has black-skinned characters from Greater Harad in his story. Without going through all of these individually, he's comparing a vial of healing of elfin seeds to the only vial left of the waters of awakening. Okay. Now, I'm not a scholar of Tolkien here, but I'm going to assume that, like, Gandalf belongs to the Tolkien estate. Maybe the concept of dwarves, but you know, that doesn't belong to anyone, because that's a sort of scène faire or merger doctrine or, you know, public domain. You know, long have there been stories about certain things. So what is going on here, I think this man is a big fan of Tolkien, makes stories in the Tolkien universe, fan fiction, and then when they continue to make new Tolkien works without him, and he finds similarities between his universe and their universe, then he gets upset and wants to file a lawsuit. Why the lawyer has allowed him to file this lawsuit, I do not know. I'm assuming the lawyer is taking their chances as well, because this does not seem like a very well thought out lawsuit. So a couple concepts. Because this is important. I get this question a lot. You know, this came up with Star Trek Axanar. This comes up with lots of any fan fiction that you write, you run into this issue. There are lines to be drawn, and if you don't know where the lines are, you're going to find yourself on the wrong side of the line, and you're going to be upset. A derivative work refers to a copyrighted work that comes from another copyrighted work. Copyrights allow their owners to decide how their works can be used, including creating new derivative works off of the original product. Derivative works can be created with the permission of the copyright owner or from works in the public domain. We actually have a better definition from the U.S. Copyright Office in Circular 14 here, copyright in derivative works. A derivative work is a work based on or derived from one or more already existing works. Common derivative works include translations, musical arrangements, motion picture versions of literary material, art reproductions, abridgments, and condensations of pre-existing works. Another common type of derivative work is a new edition of a pre-existing work in which editorial revisions, annotations, elaborations, or other modifications represent as a whole an original work. To be copyrightable, a derivative work must incorporate some or all of a pre-existing work and add new, original, copyrightable authorship to that work. So they give some more examples: a drawing based on a photograph, an adaptation of a dramatic work, a new version of an existing computer program. Who has rights in derivative works? Only the owner of a copyright in a work, the original work, has the right to prepare or authorize someone to create an adaptation of that work. In any case where a copyrighted work is used without the permission of the copyright owner, copyright protection will not extend to any part of the work in which such material has been used unlawfully. The unauthorized adaptation of a work may constitute copyright infringement. What I'm getting at is that Polychron's adaptation, or Polychron's The Fellowship of the King work, although it may have started as inspired by, it turned into a whole book and a concept for a 7 or 8 part book series, but it is more than just inspired by. He actually admits it. I know that the lawyer was trying not to admit it, but he actually admits it in here. In his list of similarities, a lot of the characters that he's saying are similar to his characters are characters that belong to the Tolkien universe, not characters that are original to his universe. Now, could he own something? Yes, he could own what he added, not what is copied from the Tolkien universe. But this gets really weird. There's a really weird operation of copyright law here. So the Tolkien estate, I'm just going to refer to the defendants as the Tolkien estate. The Tolkien estate owns what, their rights. I know there's a division between the Tolkien estate and the Middle Earth Enterprises or something like that. Let's just refer to all of the Tolkien stuff as Tolkien and Polychron as Polychron. So the Tolkien people own Lord of the Rings and what J.R.R. Tolkien created. When someone comes along and creates fan fiction of that and adds something new, a character or a plot line that didn't exist before and all that, but in order to add that character and plot line and have it be at all relevant to the original material, you're going to have to use material from the original. So there definitely is a level of inspiration that is not copyright infringement, but once you start to use the characters, the scenes, the settings, previous plot lines, the history, those are all things that belong to the Tolkien estate. So when Polychron uses those to base or found his books, his universe, his editions in something so that readers will enjoy his story set in the same universe, he is creating a derivative work. There's really no way around that. I have not read his books for myself, and I have not seen the Rings of Power TV series, so I can't tell you for sure that there couldn't be something in there. So speaking generally and speaking with that huge caveat that, I'm speaking hypothetically about the overall thing and not, having seen it myself. But knowing that the Tolkien estate does own The Lord of the Rings, he is admitting that he's using Lord of the Rings characters in his story. Now, he presented this, and they rejected him, and they said, no, they don't want to work with him, so doesn't that mean he can go do whatever he wants? Because, no. No, you can't just go do whatever you want because you got rejected. If they don't want to work with you, you don't get to work with them. That's as simple as it is. Go make your own story with your own characters, your own universe. Figure out, which goblins are protected and which characters are not protected, and make your own story. Maybe you can't call your wizard character Gandalf, but you can create a wizard character like Gandalf and make your own universe. That's something. Now, he also has a mistake here that I think is going to be fatal to the case. So what's going to happen is these defendants are going to write a motion to dismiss. They're going to file a motion to dismiss under Rule 12b6, Federal Rules of Procedure 12, subsection b6. It's a list of reasons why you can motion to dismiss a case, and one of them is failure to state a claim. That means that you didn't connect the dots between your facts and a legal remedy that a court can grant. You might say, I'm really upset that there's a pothole in front of my house, but you may have no legal right to sue anybody over the pothole in front of your house. So as much as you may feel you're wronged and you may make out a perfect legal claim for how you shouldn't have a pothole in front of your house, you're not going to have a legal claim because there's no legal basis for it. There's no written law that says you can sue over a pothole in front of your house. So what the defendants in this case are going to do is file a motion to dismiss, and among the different grounds, they're going to cite that, of course, that this guy doesn't own what he thinks he owns, that he's created an unauthorized derivative work, that they've refrained from suing him, but, he's now sued them. They may countersue him. The problem with countersuing is a motion to dismiss gets rid of the case now or shortly, whereas countersuing maintains the case. So they may motion to dismiss his claims while also filing their own counterclaims. So they could sue him for copyright infringement. But one of the more fatal things I saw here, something that I've run into in my own practice, when you register a copyright, you have to know what this piece of paper means. This copyright registration for Polychron's work, The Fellowship of the King, is deficient. It is missing something. Since it is derivative, since it is based on something, it has to say what it's based on and who owns that copyright, and it has to disclaim ownership of that material. This, according to this piece of paper, he's saying he owns the copyright for every word he wrote. Nothing is based on anything from the public domain. Nothing is based on anything from the Tolkien estate. Now, it is true, copyright registrations often have little mistakes on them, and we do have court cases that say that you can make mistakes on copyright registrations and continue to maintain your suit. But this is, I think, a fatal mistake. The mistake itself isn't fatal. It's the reason for the mistake, because he doesn't own anything. Because he doesn't own the rights to the underlying Tolkien works, because it's a derivative. He was not able to, didn't know that he should disclaim those things in here. And by not disclaiming it, I think that the opposing side is going to simply be able to point to his invalid copyright registration and therefore his inability to maintain a suit. So they'll probably file a complete motion to dismiss with all the different reasons to dismiss, because you have to. But I think one of the primary reasons is going to be the invalidity of his copyright registration. That copyright registration only stands for the procedural act of sending something to the Copyright Office, going through their form and properly filling it out, and, filling it out properly enough, and then they examine your application and they approve your application. It doesn't mean that there are no problems with your copyright registration or with your underlying copyright. It just means that they couldn't identify anything that was wrong with your application. That's all. It doesn't. It's not an adjudication of your rights. So yeah, that's I think that's going to end in a quick train wreck for the plaintiff. He claims it's a wholly original work, and I don't think that it's even close to a wholly original work. A wholly original work would be copyrightable. Even an authorized derivative would be copyrightable. His additions, if he made a new universe, if everybody got in a spaceship and went to a new galaxy and started an entirely new adventure, he would own that part of it, and he could write his own new adventure, but without the Tolkien characters. And this bar is not terribly high. Like, he can still have a wizard character, and he can still have hobbit characters and everything. He can't call them Tolkien's names. He can't call them Gandalf, and he can't call them hobbits, assuming that Tolkien owns hobbits, because I don't think that's a thing that was in the public domain. But you get what I'm saying. He can make his own fantasy universe. And it sounds like he's capable. It sounds like he can make his own fantasy universe. One last nail in the coffin, though. Here on his author's page on Amazon, he does recommend The Fellowship of the Ring by J.R.R. Tolkien. So if he's saying that this is not based on Tolkien's work, it's not derivative, it's wholly owned by him, yet he is putting it right next to his thing. Meanwhile, also, Amazon can't find the page for his book all of a sudden. I'm guessing that means that his book, The Fellowship of the King, The War of the Rings, Book 1, is no longer being sold by Amazon. So thanks, Tack, and thanks everyone who submitted that. That was a really interesting copyright discussion. Fan fiction runs into big publishing once again. They own hobbits. Okay, yeah, I figured. If you notice the date, he registered the copyright the same day he notified the Tolkien estate he had a manuscript he wanted to send them, presumably so he'd have protection if they stole the work. Yeah. Well, I mean, I don't think that's wrong. If I was going to send a manuscript to someone, yeah, I'd copyright protect it. Sure, I don't think that's a problem. Sometimes you even have non-disclosure agreements or various agreements, about how the copyrights are going to be handled and how something's going to be handled. Sometimes there's even people who read. There are readers who create a kind of a wall, an intangible wall with their behavior. They will read your manuscript and not report to their employer about what they have found unless they think it's worth pursuing. Therefore, your employer, the publisher, Amazon or whatever, can go make a thing and say, without a shadow of a doubt, yes, we read your manuscript, but we didn't read your manuscript. We had our employee read it, and they have not told us anything about it because we rejected it. It was never read, I guarantee it. Very probably never read. They get lots of fan fiction requests. I'm absolutely certain that they have people like this stalking them and probably saw him as just another one of them. And it probably feels insulting to him. And I'm not knocking his authorship. He probably did a great job. I've nothing bad to say about the guy, just his lawsuit. The lawsuit, I think, is frivolous. And I'm really not sure how he got a lawyer to file it. Maybe the lawyer is not confident because the lawyer needed to file it as a verified complaint to make sure everyone knew that these were his words and not the lawyer's. But the lawyer took the money, assuming that there was money in being hired. Maybe there wasn't. Maybe the lawyer's like, yeah, sure, I'll file that, but you got to pay for all the expenses and I get 40% of any winnings. I don't know. If he's paying the lawyer, which he should, I don't know how you could file this complaint. But we'll see how quickly this gets dismissed. But if there's something original in plaintiff's work, then it belongs to them and therefore it's copyright infringement and D will lose. What happens if Amazon did use stuff, original stuff, original contributions from Polychron in the Rings of Power. So let's say that they did read his manuscript, they did reject him officially, but then they did go on to write their own version of, you know, using his things. At some level, they're allowed to do that. So he complained about, you know, using the cover of his book. Well, I don't think they used an exact image of the cover of his book. I'm going to assume that it was like a video that happened to depict the same things happening that were on the cover of his book. I don't see how anything but showing that exact image. Like, I don't mean depicting the same scene. I mean showing that exact image. Like, oh, a dragon, you know, shooting fire at medieval soldiers. Like, oh, that's so original that it's copyrighted. But Dimitris Polychron owns this concept. No, you don't. No, you don't. Pretty sure Tolkien is going to sue for copyright infringement and then end up owning the Fellowship of the King. Well, at least the Fellowship of the King will be pulled from publication if they sue. If Amazon or Tolkien want it pulled, it'll get pulled because it's derivative and it's an unauthorized derivative, in my opinion, just based on what I've seen here. So give me that much of a leeway in it. Oh, the eagle. Yes, he claimed it was. Oh, there's the eagle. Yes, okay, this is the eagle. I didn't see it at first. The eagle is. Oh, I don't have. You can't see my cursor. The eagle's right there in the middle of the flames. I didn't see it at first. But I'm assuming a great eagle and a dragon, which are both public domain characters, in my opinion, can be easily used in any scene. I'm just thinking that this plaintiff doesn't really understand Senefair, derivative works. Basically, they don't understand copyright, and I'm questioning the lawyer that allowed them to file this. Well, not even allowed. Drafted a complaint based on their allegations. What if the characters only share names with the original work but have completely different behaviors and personalities because, well, it's a bad fanfic? Okay, that's a good question. Where is the line there? So if they shared all the names, that's going to be one thing. If they have different backgrounds but the same names, well, that's going to go in the other way. There isn't like a form with a bunch of checkboxes and then you add up the numbers and see who wins. These questions get sent to a judge as a fact finder or a jury as a fact finder. And then the jury will hear all of those facts. So it's difficult with these questions to isolate one issue and say, you know, if he used derivative names but used original plots and backgrounds, you know, how would a jury decide that question? I don't know. How would you decide that question? Go ask 12 people and see if they would decide it all the same way, and try to decide for yourself if you could get them to all decide it the same way, or even by a supermajority of like 8 of 12, like they're doing with the death penalty in Florida. Likewise, you could have copyright infringement without even using the character names. If you wrote your own Tolkien-style story and you used all of his settings and his scenes and you described everything the same way and you put everything in the same place and you didn't refer to anybody by the same names, though, you could still have a situation where a jury has to answer whether that's copyright infringement. You could still copy all of Tolkien, change the names, and still have it be copyright infringement. And vice versa. You could copy all the names, change the plots, and have it not be copyright infringement. The jury or the judge are going to be dubious. They're going to be skeptical of why you did it the way you did it. You don't get to present these things in isolation and be like, haha, I fooled the jury. That, you can. It happens that juries are fooled. It's just unpredictable. It's not as easy as it sounds. Anyway, so that's all I have for you today. Thank you very much for all of your support. Thank you for coming and watching. Thank you for your love and your understanding and your comments and your chats and your thoughts and your love of the law. Thank you for your money. Thank you to Eevi, Ugly Grill, Torpedan, PureMagma, Eric Tams, Gutbrodj, TechTechPotato, King Aries, and Kyle Siefring. I think we have a couple new ones too. Let me see if I can call you out. I think the Blood-Soaked Survivors is back. Don't credit or shout out is another one of my my supporters. Great. So thank you very much. Don't credit or shout out my account. All right. Love you guys. I'll see you in the videos that drop. Have a great week. Let me know what you think in the comments below.